The Bobby O Show.
Welcome to the Bobby O Show. My name is Bob O'Potzner. I'm a partner in the law firm of Collins Hannafin. I was head of litigation department for many, many years. And today I'm going to do a show which is atypical for me. I'm going to do a show about the law. I've been getting phone calls of late from people having landlord-tenant problems. And I'm talking about the person who resides at a property which the owner would be called the landlord and the individual who rents is the tenant. And I have a young man who I am, a matter of full disclosure, consider me my mentee in the litigation area. He's very knowledgeable. I can't say he's an expert because under the ethical rules in Connecticut, you can't call yourself an expert, but he's very, very knowledgeable in landlord-tenant law. I'm going to have John Bowser speak to us a little bit about that topic and certain issues concerning that. John, welcome aboard.
Thank you very much for having me, Bob. I really appreciate it, and I appreciate all your kind words. I was fortunate enough to be mentored by you. I'm the current head of litigation department at Collins Hannafin, which is an esteemed and I think I can fairly say old and established law firm in Danbury, Connecticut. And I appreciate you having me on to discuss this very serious topic, particularly since COVID. Landlord-tenant law has been a huge area. People who maybe can no longer afford due to various, interest rates or financial circumstances to own their own home are all renters, and the supply of rentable properties, particularly in our area, it has certainly not met the increase in demand. So,
John, if you could just give us a little bit of your background. I know a minute of your background. I know you worked in the court system as a clerk for a while. Just give a little bit of your background for about a minute. We'll get into the topics thereafter.
Sure, I'd be happy to. I'm a graduate of UConn in Storrs, Connecticut, who are consistently better than Duke in many men's sports. And I say that only as a rib to Bobby O, whose Duke preference is readily apparent during your opening credits. I am a graduate of Roger Williams University School of Law in Bristol, Rhode Island. I was both a what they call a temporary assistant clerk in the Connecticut court system in the Judicial District of Danbury, and also a research clerk who did research and memo writing for the judges on the bench before I became an associate, later a partner, and then the head of the litigation department here at Collins Hannafin. I am a former president of the Greater Danbury Bar Association. I'm members of the Bethel Education Foundation, and I've been practicing in the area of landlord-tenant law for a little more than 15 years now, which is hard to believe. But I am a lifelong Ridgefield resident. I live in Bethel now. I, in fact, used to do the color commentary for high school sports for RHS, which I believe appeared on this very channel. But that was a good 20 years ago, and I had significantly less gray hair at the time. So if you recognize my voice, it might be from that.
John, it's very interesting you mentioned about the Duke-UConn connection, because that very jersey in the start of the show, the number one jersey of Duke, Rebecca Lobo, all-time great women's basketball player at UConn, was at a fundraiser at the Amber Room, of course, where else in Danbury. And her mother had passed away from breast cancer, and it was a fundraiser for breast cancer, et cetera. And I went up to Rebecca Lobo. I'm 6'2", and I looked up to her. She's about 6'5". And I said to her, I said, Rebecca, would you mind taking a picture with me in my Duke shirt? And she saw the shirt and said, I don't mind at all. We beat Duke every time I played them, so I don't care. So that'll be enough of the razzing of my Duke-UConn thing. Let's get to the topic at hand. I asked John, before we get into the actual eviction process and the implications of how it goes about, to talk a little bit about what you should look at if you're looking at a lease. And this is especially directed to, as far as I'm concerned, the young people who may be going to WestCon, for example, who now are renting a place in town and get handed a lease, what do they do? So, John, tell us a little bit about both the lease. Let's start with what the lease they should look for in the lease.
Well, it's a great question, Bob, because obviously this is where everybody starts, right? When you're looking to lease property, the first thing you want to do is look to the property itself, of course. You have to look at the property when you're renting almost as though you were a homeowner. You want to concern yourself with the location of the property. You want to concern yourself with drainage. You want to concern yourself with access to public accommodations, all of those things. And then once you've finally picked a property, whether you're working with a realtor or you're working by yourself, the next thing you have to do is look at the lease. Connecticut, in my opinion, has done a pretty good job, especially in the last 5 to 6 years, really since COVID, of ensuring that there were certain tenant protections that are located within the lease, and they do that in two ways. One, they try to cut out what they call junk fees, which is a federal initiative to limit the amount of fees that a landlord can charge a tenant just for applying for a lease. And then after that, the Connecticut legislature has also limited what they call permissible terms within a lease. Now, here's the caveat I'm going to give to everybody. If a lease contains permissible or rather unpermissible terms, okay, that has yet to stop a lot of landlords from including these terms in their leases, not because they're grandfathered in, but just because the language in the leases hasn't changed in the last X number of decades. So you will see a lot of terms in a lease that may be listed as unpermissible or impermissible terms in a lease. And I'll give you an example of a couple of them. The first one, the classic one, is landlords have an obligation under the law to ensure that the health and safety standards of a building are being met. That includes abiding by all state, municipal, and fire codes in the leased premises. Leases sometimes have provisions wherein a landlord tries to turn that obligation onto the tenant, or to have the tenant assume the obligations of a landlord in terms of compliance with health and safety. That term is impermissible. If your lease includes the assumption of a health and safety standard by the tenant, then that term of the lease is unenforceable.
John, one question,
Sure.
please. Not to get too technical, but let's suppose the lease has one or more of the impermissible provisions. Does that void the entire lease or just the provisions involved?
It's a good question. That usually renders the lease voidable, but not necessarily void. In other words, if you bring it to the court's attention or to the landlord's attention, you would say this is a cause for redrafting this lease if you wanted to. It doesn't mean that the lease is automatically void, because if that was the case, then the lease would be void ab initio, and all of the provisions of that lease would be ineffective as of the day they were signed.
Now, since I'm just a little layman, I've only been a lawyer for 40 plus years, I just want to say that ab initio means at the outset, correct?
From the beginning, exactly.
So go on. Do you have any other? I think, by the way, if you were the landlord, and this is where the landlord needs to be careful and not be cute, and that's where the landlord really would need to have a lawyer, I think, prepare leases, especially if the landlord has multiple buildings or units. And that is, if the landlord puts an impermissible lease provision in the document, a lease being, of course, the written agreement between the renter, the landlord, and the tenant, then that landlord may risk, if, let's suppose, a tenant refuses to make payments for whatever reason, and the landlord tries to evict, that is, throw out the tenant, might there be a defense for the tenant to say, well, wait a minute, I didn't pay the lease because of the impermissible term? I'm sure you've probably seen that in your day, right, John?
Well, absolutely. So I'll say this. Just because these terms are non-permitted does not stop any landlord from putting them in a lease. I see them almost all the time. The most common of which is the tenant waives their right to an eviction and will immediately leave the property upon any sort of a breach. That, despite the fact that that has been a non-permitted term for 30 or more years under the Connecticut statutes, I see that term in residential leases all the time. And Bob, you did something which is absolutely right, and that's you laid down some base definitions right? You mentioned that a lease is the contract for the long-term rental of property. A tenant is anyone who is residing in property, and there are many kinds of tenants. There's tenants at will, there's tenants in common, there are squatters' rights in Danbury. There are numerous types of tenants, but for the sake of today's argument, what we are talking about is a landlord and tenant in a residential relationship. The rules regarding commercial relationships will be, in many cases, totally different. And now that we've done some of that defining, I want to back up another thing you said, which is that if you are considering entering into a lease in the same way you would if you entered into any contract, my strong advice to you is to consult an attorney first before you sign on the dotted line. There are a lot of circumstances I see on an almost daily basis where an ounce of prevention is worth a pound of cure, meaning it is much easier to correct a lease before you sign it than it is to try to unscrew up a situation you've gotten into because the lease is inaccurate or incorrect or says something that doesn't apply to property or something that you would never have agreed to if you had read it more closely.
And John, John, just the other side of that, however, let's suppose you're in Stamford where they have probably what, 2,000 or 3,000 units in the big Stamford area, all these apartments. Try negotiating a term of the lease different, and you'll be told, because they have a lot of requests for rental, you'll be told, I'm not changing anything, but it's worth asking. The other thing, John, is I want to throw one more document on the table, and that is beyond the lease agreement. I'll tell you how well my two kids are well trained. My daughter went to Jessica, who you know well. You know Matthew as well, my oldest child. Jessica's at Miami of Ohio, her senior year in college, and she and 6 girls getting a beautiful apartment they're renting. And Jessica calls me and says, hey, Dad, should I get an agreement with the other 5 girls so that we have an agreement just in case someone doesn't pay the rent? I said to myself, I guess the tuition for college has been very, very well spent. And just to throw in a topic, if you're going to have a tenancy where 2 of you or 3 of you or more are renting an apartment with the landlord, there should be some agreement. It doesn't have to be fancy schmancy, but some kind of agreement. Because what if one person flunks out of college and I'm not going to pay the rent anymore? And you need to be careful. And I was able to get in the lease for my daughter where each person was responsible for their share, and they weren't, as all 6 girls, responsible for all of it. So you got to keep that in mind. Also, I do a lot of divorce work, and I've had cases in which one party signs the lease. They both live there before they're married. They break up. Who gets to stay in the apartment? So those things come up, John, do they not?
Oh, I couldn't agree with you more. I've had a lot of circumstances, and this most often crops up with college kids because you might be, cramming, like you said, 5 or 6 people in an apartment together, and let's say one of them leaves. Subsequently, the remaining 4 fail to pay the rent. That 5th one, who is on the lease, is still going to be named in the eviction lawsuit for the other 4's failure to pay rent. And as you probably know, once you're named in a lawsuit, that information is publicly available and can go on to affect things like your credit score. So it's very important that you have an agreement whereby between roommates, you understand exactly what the obligations of each one is.
And John, if you're the landlord, it'd be very important to put in who are the allowed tenants. You might want to talk about the fact that if let's suppose a guy and a gal get it together, and all of a sudden they bring in 3 or 4 of their friends, it's important for the landlord to have provisions, and not, John, to have limitations as to who or how many kids can be there. Now that we've scared John from every college student in America from saying, you know what, I'm not going to sign a lease. We're going to have a lot of kids living in tents under 84. Let's go on a little bit to one more topic before you go to the eviction process, which is security deposits. What's a security deposit and how does it work?
Well, the first thing I want to tell you is, if I could just, I'll work it in. A security deposit is an amount of money that you put into escrow as a tenant with a landlord. Escrow means that the landlord becomes something like a trustee, someone who is entrusted to keep this money inviolate and separate. Title to a security deposit never becomes the property of the landlord. It always stays the property of the tenant. So the Connecticut security deposit statute is very clear on the procedures for security deposits, and just like non-permissible lease restrictions, I see people daily who mess up or act in non-accordance with the security deposit statute. If you're following along at home, it's Connecticut General Statutes 47A-21, and it says, first of all, that a security deposit, or a landlord is only entitled to ask a tenant for a security deposit worth 2 months' rent, the equivalent of 2 months' rent, and that is only if that tenant is younger than 62 years of age. If a tenant is older than 62 years of age, the protection for our more senior citizens allows a landlord to only request a security deposit of 1 month's rent. And here's a real mind bender in there. If a tenant turns 62 during the course of the tenancy, a landlord is actually obliged by law to return 1 month's worth of security deposit to the tenant.
John, I didn't know that rule. When I turn 62, I'll be very concerned about checking that particular statute out.
You got 10 years to go. You're fine.
Here's the thing, John. Also, am I correct? The law is still that when the landlord gets the security deposit, the landlord is required to put that money separate into a separate account from his own or his own accounts, so that the interest accrues, small as it may be nowadays, to the tenant. But you cannot mix the two together. You're personal with that.
Absolutely right. So security deposits really have there are three issues that arise from security deposits. There's the receiving the security deposit, the amount of it, which we just discussed. There's the keeping of it and the interest that it is paid. And then there's the returning of it. So briefly, let me return to the second topic, the keeping of it. Security deposits must be kept in a separate interest-bearing account. You can't, what we call, commingle the funds. If you're the landlord, you can't just dump it in your savings account and assume that, okay, $1,200 of that belongs to my tenant. It has to be a separate account, and it has to bear interest at a certain rate, which by law can be no less than 0.5%. It's called the deposit index. And if you go to your bank, if you're a landlord, you can open up an account and they will ensure that you have the correct interest-bearing account for security deposits. Right now, in 2024, the deposit index rate for security deposit accounts is 0.55, 0.55% interest. So it's one of the lowest. It's almost at the statutory minimum of interest that can accrue on security deposits. So don't expect to get a tremendous amount back. Here's the most important rule that the most landlords mess up about security deposit interest. The statute states that security deposit interest must be accounted for and paid annually to a tenant upon the anniversary of the signing of the lease. Nobody does that. If you're lucky, a landlord will hold on to that interest. It'll be in the account, and when you leave, they will return the security deposit amount plus that interest to you. Ironically, that actually results in you getting more money because interest is compounding. But according to the law, that interest is supposed to be paid annually back to the tenant, or else credited toward the next rent payment due from that tenant.
John, it's interesting you mentioned that because, as you know, I do a tremendous amount of divorce work. And as part of the divorce process, each side has to do a financial affidavit disclosing all their assets. And I would say to you, maybe 5% of the clients, and these are all good people, and I know they have an apartment they're renting to somebody, or they have a duplex, whatever. I said, by the way, do you have a security deposit? Sure. Of course I do. Well, where's that? It's in my joint saving account with my wife. And isn't there, the law I thought used to be, there could be criminal for commingling. Is that true, or am I wrong?
No, you're absolutely right. So the penalties for malfeasing in any way or failing to follow the rules for security deposits is both potentially criminal consequences, because the Connecticut Banking Department is actually responsible for ensuring that security deposits are properly kept and paid, but also if you fail to return any portion of the security deposit or the interest properly and in accordance with the law, the tenant is entitled to recover double damages. So that can be considerable, particularly in lengthy leases or where the amount of rent is already fairly high. If you're paying $2,400 a month and you've taken a 2-month security deposit, then you're talking about $9,600 that the landlord could be responsible for, plus interest, to a tenant for failing to return that properly. So,
John, I think the last 3 or 4 cases I've had with people who were renting property in, let's say, Richfield, the housing market for rentals, if you want to have and I've had many cases where one party stays in the house that they have while they're trying to sell it, the other one wants to rent a place in Richfield, for example, $4,000 a month is not unusually high rental price. So therefore, you're paying possibly $8,000 into an account for security deposit purposes, not insignificant. And John, please tell us last part of the security deposit, and we're never going to get to the whole eviction process. That'll be a second show, John. But John and I never talk too much. John, what is the purpose of the security deposit as relates to the landlord and as relates to the tenant? What is the money to be used for legitimately?
Well, that's a great question. So one of the things that a lease can do in the residential context is it is permitted to say that your security deposit, you, the tenant security deposit, can be used where you fail to pay rent, but it's not automatically assumed. That has to be a term of the lease. The security deposit is intended only, absent a provision to the contrary, to protect the property itself from any damage caused by the tenant upon removal. So that brings us to the third topic on security deposits, which is the return. The security deposit plus interest is due from the landlord back to the tenant no later than 21 days after the tenancy is terminated. Now, the question arises, what happens if a tenant leaves and they fail to inform the landlord where they should send the security deposit, right? If you don't have a bank account of the tenant that you can transfer the money into via Zelle or Venmo or one of those, and you don't have a forwarding address, it behooves you, the landlord, to contact them any way you can, whether it's by phone number, whether it's by email, and find out where the tenant wants this sent to. Because once the tenant gives you a forwarding address, you have 15 days from the date you receive that address to send to them either, number one, the total security deposit and interest, or number two, a written statement of itemized deductions as to why the landlord retained any or all of the security deposit and the interest, plus returning anything that's left over from the security deposit. And failure to abide by any of those terms used to be 30 days. The 21 days is a fairly, I think, 2 years now, old provision. But failure to abide by any of those very tight terms can result in double damages being returned to the tenant. Now,
John, I want to comment on that before you do that. It's therefore very important. My daughter, she said, "Dad, should I take any pictures of the apartment when we move in?" Very shrewd girl, as you can imagine. And the answer is yes. And the reason for that is because even though it's the landlord's burden, I believe, to prove that they're holding back some money because of damage, when you do your inspection, if you're the tenant, if you walk around and you see a big hole in the wall or some other problem in the structure, take a picture. Also, be very careful if you're a tenant. Don't start banging nails and putting things in the wall. You can get hurt in that regard. So one thing is, suggest you take a picture and somehow have a little note somehow as to the date the picture was taken. The other thing is, when you leave the apartment, this especially for the college students again, who may be out-of-staters coming here, you got to leave the landlord with your address to forward the money back to you on. Many people don't do that. One suggestion I have made when I used to do landlord-tenant law, or before unless my kids call me for a problem. Now they own houses, but that's a different story. The answer is that you might want to leave a forwarding address to where in the lease itself. The downside of that, however, if you're going to be a student who wants to skip out, then they'll know where to find you through your parents. So, right, John, there's a double-edged sword in that regard. But
it is always a balance, and I couldn't agree more with regards to documenting the damage that you see both upon the move-in and upon the move-out. Your right to have an inspection of the property, which includes both the systems in the property and also any potential defects or damage in the property, is actually enshrined by law. And the other thing I want to mention about inspections particularly is tenants with pets, okay? If you are bringing a pet into a leased premises, it is crucial that you document any potential damage upon your move-in and your move-out, like we just said, and also ensure that that pet is permitted in the lease, all right? And the number of pets. If you have a dog, don't assume that means you can get a cat or 2 dogs, or in some cases 5 dogs. You know, all of these has to be with the landlord's knowledge and permission, or you're the one who's going to get charged for the scratched up floors and the, you know, the ripped window shades when you do eventually move out.
Well, John, here's the other thing. Please don't accuse me of being J.D. Vance, because I'm a moderate Democrat, strongly supporting Kamala and Walz.
Otherwise, identical.
Okay, but I would say to you, I would say this the following to you. If I were a landlord and I had a house, let's suppose in Richfield I was renting, I would say no to pets, because the pet damage could be devastating. And I'm not anti-pet. I'm not being anything negative. But if you're a landlord and you're renting your property, you got to think about the next renter who you're going to want to go to, or selling the property. And as a landlord, I'd say no. And as a tenant, don't sneak in the pet. Don't say, shh, no one will know, because it can cause you potential damages. Unfortunately, John, on this topic alone, which I think has been a very important discussion, we've taken almost the whole show. We have about 2 minutes left in the show. And we'll do another show, John, on the eviction process. By the way, eviction, of course, means having the landlord legally throw someone out of the property. I'd like to just quickly talk about the tenant leaves and leaves his stuff in the apartment. Can the landlord just throw it away? Question mark.
That's a fantastic question, Bob, and it comes up so often you'd be surprised. The first real question you have to get to before you even get to that question is whether the tenant has really relinquished possession of the property. Because if you are the landlord and you try to contact the tenant, you drive past the house, they aren't there, they haven't been there for a week, there's no guarantee that they aren't just on vacation and they failed to tell you. Although, of course, that's a provision you can put in the lease, that you have to notify the landlord if you're leaving for a certain amount of time. But unless you have some affirmative act that confirms that the tenant is intended to abandon its lease and move out, and usually that means something in writing that says they're really leaving, or else dropping off the keys or something else, as a landlord, you can't assume that they have abandoned the premises, the leased premises. There's a particular provision of the statutes that says if there is an assumption of abandonment, then the landlord has to do their best and send a certified letter to the tenant at the last known address, other than obviously the leased premises.
And John, not to knock you off while you're rolling, you have like 10 or 15 seconds left. You've done a great performance. I just want to say one more thing, and that is that even though I'm a moderate Democrat, the concept of limiting what a landlord can charge, I have some questions about that, because as a landlord, you're taking a lot of risks. This has been John Bowser, who you can see has been very well trained by whoever his mentor was. Bob Potts on the Bobby O Show. We'll have another show with John Bowser. Thank you very much. Hope you enjoyed the show. Hope you learned a lot.
Thank you for having me, Bob.